All right, everyone, hello, and welcome to our Week 10 module. We're talking about the Supreme Court. We're switching it up a little bit, different style today. We're going to do it in class, but I'm hoping still to be able to provide the recording for you of the lecture so that we can have that resource available to you when it comes up to final exam time, and you'll be able to rewind, replay, rewatch to your heart's content. It's also my intention, although it's not always, I don't always keep on top of this, but I would like to have lecture notes available to you before you head into the final exam as well for your revision purposes. Not the full lecture notes, but at least the slides. So as you know, we're talking this week about the Supreme Court. My intention is to take a break about halfway through the lecture. That's pretty standard for me. With an hour and whatever it is, 20 minutes, I think that's a long haul. You deserve a break, I deserve a break, so we'll do that. And also, if I can, I'm going to try to have a video clip for you guys at the end of the session wherein we learn a little bit about the Citizens United case that's recently been deliberated by the Supreme Court and some of its ramifications for one of the major themes that we've been talking about in this semester, which is the role of corporate power and interest in the Supreme Court. One of the themes that we'll be elaborating on today, in fact, is precisely this idea of the Supreme Court having largely throughout its history, and perhaps once again returning to this major dynamic of its history, its role in relation to corporate power and supporting the agenda of corporations in the country. So the United States has, of course, a penchant, as the French would say, a tendency, that is, for legality, right? It's a country that likes to practice litigation, and one has to stop and ask, what does that mean to live in a country like that? It's not the only country like that. Ireland, Australia, I can tell you, a number of other countries are like that. Most Western democracies like to practice litigation. They have an extensive court system, legal system. But in the United States, I suppose it's fair to say that there's a slightly different dynamic going on there. It's not an unusual country in some ways, but the Supreme Court in the United States has a huge amount of autonomy relative to in other countries. And that's something we really need to think about what's going on with it. Part of the reason, I suppose, is the way the Supreme Court justices are appointed. Okay, they're appointed for lifetime appointments. They have a certain kind of aura about them, culturally speaking, within the United States political culture. Supreme Court justices have an aura about them that is a certain mystique that gives them a sense of presence. And we'll want to ask today, where does that presence come from? Where does that sense of their presence come from? And of course, as the sort of grand interpreters of the Constitution, that sense of presence, that sense of seriousness that we take their word with is important for them, because otherwise their interpretations of the Constitution wouldn't stand up under scrutiny. People might ask questions. So it's very important for their legitimacy, and that's a key word here, that they have this sort of cultural mystique. Many experts would say that the judiciary, and the Supreme Court specifically, is the least democratic form of government. Yet, the Supreme Court has at times also been a champion of popular democracy, and this is the puzzle, right? The Supreme Court has also been a champion of popular democracy, and that is a puzzle, right? Why has a body that has so consistently favored the elite occasionally veered towards popular democratic tendencies? In that regards, defending certain interpretations of the Constitution as a popular democratic document, which favors democratic fairness and deliberation in its process, I would argue, and I think the book argues too, that the Supreme Court has actually served as a beacon of hope for marginalized citizens in favor of, in addition to sometimes being, that is to say, a guardian of elite privilege. And it is this complexity of the Supreme Court that makes it an interesting case study as we try to survey this semester the stakes of the democratic debate in the United States today. So on this slide you can see what we call the tiered structure of the federal court system. And I'll just draw your attention to some of the principal highlights of what we can observe going on in relation to the federal court system. First of all, the United States District Court is probably the one that most of us in our lifetimes, if we ever have any dealings with the court, this is where we would interface with it. It's the entry level of the US court system. It has what we call general jurisdiction, a court that has authority then to hear a wide range of cases. It should be said that, as we see in the diagram, there are other courts that we might want to attend to, right? It's not that the district courts are the only real way to enter this. Of course, there's a number outside of the judicial branch that are federal courts, okay? Because here's what we're talking about today, federal courts. There are, of course, local courts beyond that in the state level. Those aren't what we're talking about today. The federal courts and other entities outside the judicial branch include military courts, the Court of Veterans' Appeals, the U.S. Tax Court. These have federal jurisdiction, but they're not considered for the purposes of what we're talking about today to be part of the federal court system as it's properly addressed. It just so happens the military is a federal organization by and large, so it has its own court system, etc. The Court of Appeals are the appellate courts. We have 12 regional circuit courts of appeals, and of course 1 U.S. Court of Appeals for the federal circuit. Cases of the courts of appeals are not retried, okay? This is sort of like a technical court. You don't appear before it. What happens is the judges review the transcripts and then will announce and pronounce if they believe a mistake has been made by the lower courts.
What does that mean, circuit-based?
It means that they can travel. It means that there's, they will, it's an old terminology that used to come from the fact that judges moved around the country.
Yeah, the lawyers.
Yeah, so like there would be a circuit court that would basically, the judges would travel around their district. Okay, so you wouldn't necessarily have to go to them. You could wait until that day of the month that they would be here locally.
Okay.
So today we're going to focus then on the Supreme Court. And one of the interesting things about the Supreme Court is that when the founders envisioned it, it wasn't necessarily clear that it would be an equal branch of government with the president and the Congress. So today we're going to try to understand where it happened in the history of this body that it became an equal chapter or an equal branch of government. If you're ready, I'll move on. So one of the things you need to know about the U.S. Supreme Court is it has a very similar way of making law and thinking about law that basically inherited from the British. Okay, it is a type of legal system that very much relies on precedent as the basis of its lawmaking. And I'll put that term up on the board here for you. Precedent is very, very important. And if we had more time, we could go into some of the principles of this tradition. It's the common law tradition, if you want to know the truth, okay? That's what it's called technically, the common law tradition. One of the important terms that comes from the common law tradition is the term stare decisis, which is a Latinism, which means let the decision stand. Okay, it's not in your textbook, but I'm just letting you know. Independently of your textbook, this is something that's important. If ever you take a law class that is about a legal system that is vaguely British at all. Irish one, the British one, Australian, Canadian, American, tons of others around the world all practice this common law tradition. And what that means, and it's different in France, right? If you go to France, it's a different law tradition altogether, okay? But the common law tradition means that interpretation is everything. That means that rather, when the United States became its own country, rather than throw out all the precedent, all the established decisions of the history of the British court system, because the United States has been part of the British system, okay? But by the time it arrived as an independent country, its question that before it was, do I throw out all this valuable case law decided in British courts up to this day, or do I keep them somehow as sort of memories of my legal mindset? And even though I'm now living in a republic, some of those courts' decisions may be still relevant. So British law, even though it was now American law, stood, and the record of British law be established. So in other words, if in British law's common law tradition we still had a respect for the Magna Carta, and you know what the Magna Carta is, of course, it's that foundational document of democratic thinking, that too would carry on. And it carried on, of course, in India, Ireland, all these other countries around the world that used to have the British law tradition, okay? So common law is very important. And the Latinism that tells us what that term means is, what common law means is stare decisis, let the decision stand, okay? It's basically a Latin way of referring to the concept of precedent. So, that said, the United States was a new country, and certain things did not have precedent because of the fact that we now had a constitution which did not specifically delineate the type of power that the Supreme Court would have in the land. Okay, so that's where we have to address a very important case, which is Marbury versus Madison in 1803. And the power that the Supreme Court is going to take for itself in relation to this case is the power of judicial review, right? Does the Supreme Court have standing over decisions taken by branches of government, including the presidency or Congress? How do we know, right? There's an interpretation in the Constitution that's in people's minds, but it hasn't been tested in the courts. And if it's not tested in the courts, it doesn't have the standing of stare decisis. That's the most important thing you need to know about this, okay? So we have to test it. We have to put it to the test. And in case you think these are a bunch of mindless robots sitting in the Supreme Court, they're not, okay? These are judges, human beings, right? Appointed by other human beings because they're seen to be allies or something like that, politically speaking. So they have their own mindset, they have their own personality, they have their own way of looking at the world, politically speaking. And who is the Supreme Court justice at this time? Does anyone know? He's a very famous guy. Marshall, okay? Marshall is the Chief Justice at this time. And he's a very famous Chief Justice, probably the most important Chief Justice the country's ever had, because it was under his watch that a lot of these early constitutional cases had to be established. And in fact, next week and the week after, when we start to look at civil rights, we're going to see his name pop up again, okay? And I'll go into some more detail on the ramifications of the cases he decided in the coming week or two for you. So what is judicial review power, or what is the power of judicial review, right? It's the power to look at the decisions of the other institutions of government and determine if those decisions are in conflict or not with the Constitution. So two things are going to be really important. The ability to determine what the content of the legislation or decision is, but also the ability to determine and the power to determine what it is that the Supreme Court actually means when it says this, that, or the other. So Marbury versus Madison was a decision given by John Marshall, then the Supreme Court Justice, and it's played a key role ever since in making the Supreme Court a body with standing as a separate branch of government in its own right. Some background of the case, if you want to know a little bit about what was going on there. Thomas Jefferson, who we've talked about before, had won the election of 1800. And as you know, he was an anti-federalist, okay? But the people in power up to that time, John Adams, were basically federalists. And they were very worried about what it meant that someone like Jefferson was going to be coming into the presidency as an anti-federalist. But they were, as they say, lame ducks. Do you know what that term means? When we have a lame duck president, so Barack Obama in about a year and a half will be one. It's no choice of his. Yeah, right? The election has happened in November, right? And he's out in January. So what's he going to do for 2 months? Apart from pardon a few turkeys at Thanksgiving. Not much, right? Okay. Same in the past, okay? John Adams, shortly before leaving office, however, did something a little bit radical. And you'll see sometimes presidents will do radical things at the very, very end of their office. Like they'll pardon criminals, for example, right? That's a well-known tradition where Bush, Clinton, Reagan, before, they've all pardoned basically key felons that they believe needed a break or were in jail incorrectly or did a favor for their political party. The president has that power, and it's the least controversial time of his appointment that he can do it. So he'll just all right, let it go. Clinton did a really notorious one. Mark, I'm afraid I can't remember his other name, but he was a financial felon. And it's by no means clear that the guy had a clean sheet. You know, he probably deserved to be where he was. But maybe Clinton had been promised a favor, or he was, returning a favor, if you know what I mean. So the lame duck time is one where John Adams was not really expected to do much, but he out of fear that these anti-federalists were going to change everything that they'd struggled for, he appointed a number of circuit court judges. We've just talked about them, and they were called the midnight judges, okay, because they were literally, it was like a midnight sweep. A decision in the White House to do this, to appoint these judges. And basically he was stacking the circuit court with federalist judges, okay? In other words, these people that would interpret the law, he was putting them in to try to basically prevent the anti-federalists from being able to change these Supreme Court appointments, or the circuit court appointments. So upon taking office, however, in the new session, the Secretary of State for Jefferson, who was James Madison, he refused to deliver the commissions to these midnight judges, okay? One of which was William Marbury. Jefferson had ordered Madison to withhold the commission. And what's the commission? The commission is his paper granting him his status. And Marbury appealed this decision to the Supreme Court. And he appealed it on the basis of what was known as the Judiciary Act of 1789. And the Judiciary Act of 1789 was a bill passed by Congress which allowed you, in certain circumstances, to bypass the normal federal procedure of the courts. We've looked at the hierarchy of the courts already on the previous slide. So you know that there's a sequence that you start at. The entry point is at the bottom, okay? Marbury wanted to bypass all that and go straight to the top. And he believed and argued that the Judiciary Act of 1789 allowed him to do that, to go straight to the Supreme Court with his problem about his commission. And John Marshall, Marbury, by the way, is the guy in the photo here. John Marshall made two rulings about this case. The first is that Madison's refusal to deliver the commission was in fact illegal, right? Marbury had been appointed under due process and was entitled to get his paper in his hand and to be a circuit court judge. That's the first ruling. And what this meant was that, as you can see here, this is our first conclusion from the Marbury case, was that in that instance, the Supreme Court was saying to the American public, we have the power to tell you that the president is wrong, okay? So we are equal voice with him, okay? We can trump him in some ways. The second conclusion, however, more interestingly, was that the Supreme Court actually took up the question not of Marbury's argument, but of the Judiciary Act of 1789 itself, and said that even though what had happened to Marbury was illegal, here's the puzzle, the Supreme Court did not have legal authority to hear the case because the case had not followed the due process through the laws.
Chain of command.
Chain of command, basically, yeah, if you want to put it in that way, yeah. So in this sense, the jurisdiction, the Supreme Court was saying, was limited by the Constitution. And the Supreme Court was saying it has to follow the rules. It cannot step past the strictures set out in the Constitution. It cannot allow the lower courts to be bypassed, as Marbury was suggesting. So we have these two conclusions here, and they're both very valuable, and they both show how the Supreme Court justices were shaping, at this very early stage in American history, how the Supreme Court is going to interpret the Constitution. We have an argument that the Supreme Court has to follow the rules. It's going to restrict its standing to what the Constitution says, or at least what it interprets the Constitution to say. And then the other being then that if the rules had actually been followed, Marbury, who had clearly been treated illegally, the Supreme Court would have been able to order that his commission be returned to him. They didn't do that because due process hadn't been followed. But had it been, they would have. Does that make sense? Okay. One of the key questions your book raises is whether or not the Supreme Court is constitutional. Not constitutional, excuse me. Slip of the tongue. Democratic. Everyone's looking at me with shock. The framers don't really provide for a Supreme Court in the Constitution. They provide for a judicial system, but not necessarily the shape and form that ultimately emerged. Where they did discuss the judiciary in the Constitution, it's clear that they intended it to be a rather weak branch of government. They did not want the Supreme Court telling the people what to do, right? That should only come from the legislature, the democratically elected legislature. It's very important. Over the years, however, the Supreme Court has increased in power, and that's a point of focus for us in the class because it is a very independent body, right? Now, its independence is not a threat to democracy so long as that independence is weak. But over the decades, the centuries, it's become more powerful. And that is, for many of us, a cause for concern. Now, many people say that that's not really a cause for concern because, in point of fact, the Supreme Court itself doesn't do that much. It's very, very weak in some ways. It doesn't get to hear all these cases, as we know. There is a process that has to be followed, and only a handful of cases get through to it. So, in a sense, we should say, well, maybe it's not that dangerous at all. It only hears this handful of cases. Some have said on that basis that it's the least dangerous branch. Most of the Supreme Court's activity is taken up with actually just the technocratic management of the judicial branch, right? So what's the problem there, right? But again, increasing power over the decades on top of the fact that it's already a relatively independent branch, that's a particular issue that we need to focus on. As we've stated and implied already, one of the reasons that the Supreme Court is so independent is that, unlike, say, here in Ross County, at the federal level, Supreme Court justices are not voted on. Here at the local level, we vote for our judges. And I'll stop here for a second. There's obviously good and bad things that come from that. What's potentially a downside of electing your own judges? They're not independent enough, okay? They're too beholden to the voters, in which case they're going to be interpreting the law in a manner that constantly has the fear about getting reelected in their minds, right? So if you're worried about getting reelected, you might be a little less likely to make certain decisions in terms of how you interpret the law, right? So that's one actual downside. You don't want the justices being too dependent on being voted. But at the Supreme Court level, the idea is that they're completely immune from these concerns, right? They don't have to worry about getting reelected. They don't have to worry about keeping people happy. And it's a lifetime appointment, right? So they're well paid, and they're kept in a decent lifestyle for the rest of their lives, providing good behavior, right? If they misbehave, of course, it's a different story. But the idea being that the more you remove them from political pressure, the more objective they can be, and the more their interpretations will reflect the values of objectivity. And impartiality, importantly, right? They're supposed to be non-partisan. Of course, as we know and as we'll see, oftentimes they're anything but. So how do they get to be a Supreme Court justice, right? They're appointed by the President and they're confirmed by the Senate. The Senate has a power to straight up or straight down say, no, we do not want this person as a Supreme Court justice. But in your lifetimes, you've seen a couple of people appointed by Bush, by Obama, and you know that every time one of these appointments is coming up, there's a hullabaloo, right? Because in point of fact, while they are independent and in theory nonpartisan and objective, we know that over the years, are you right there?
Yeah.
Okay, good stuff. Over the years, we've actually had huge battles because of the ideological convictions of the Supreme Court justices. So we've had, in our own lifetime, someone actually turned down by the Supreme Court for his ideological convictions. He was put forward by George Bush, and the Supreme Court said, no way, right? Or the Senate said, no way. We know that Sonia Sotomayor, who I think is the most recent Supreme Court justice appointed, as a woman, had a very tough time, and as a minority woman at that, had a tough time in the Senate to get her confirmation. Usually, the Senate takes this view on Supreme Court appointments. They want to kind of have a couple of people who are extremists on the side, a couple of moderates, and then a couple of centrists, right? But it's hard because there's an uneven number in the Senate. So perennially, there's going to be this question of like down to one person's decision. It's always going to come down to like Justice Kennedy, right, who is supposedly the centrist of the Supreme Court today. Actually, his recent decisions sort of show that he's if you look at Citizens United, as a casting vote, he seems to be veering on economic issues, at least, way more to the right than on social issues where he seems more progressive. So, but that's just to underline the argument that it's quite a political body despite its nominal objectivity. And for some people that's a problem because by definition, when the Supreme Court makes a ruling, and this is this question of whether it's too independent, when the Supreme Court makes a ruling, it's making a ruling on something that's often been legislated on or deliberated on by the People's Congress. Okay, so the people have spoken in some ways. And that's a problem when the democratically elected majority might be trying to express a view one way and the Supreme Court goes another way. For some people, the Supreme Court seems kind of out of touch in this regards. If you look at their backgrounds, they're often well-educated, well-heeled families that they're coming from. They haven't really experienced the types of things that most Americans have had to struggle with in their lives. Poverty, struggles for financial security. And then, of course, there's the fact that, as we've said, for average citizens to access and understand the workings of the Supreme Court, it can be very mystical sometimes. It's dominated by lawyers and people with, advanced degrees. And in that sense, it's very hard for the average citizen to get a voice in front of the Supreme Court or to impact on their decision making. But as we argued in our introduction, that's not to say that despite this elitist pedigree, that the Supreme Court doesn't sometimes make decisions that are actually quite strongly advancing the cause of popular democracy. One decision that we'll be talking about more next week is Brown versus Board of Education, which is probably one of the most important decisions the Supreme Court's ever made. And that was the one wherein the separate but equal clause was overturned. So we have conflicting views now on the judiciary. Conflicting views on the judiciary. In fact, there's two major theories, but the book adds a third. And I kind of like that third theory, so I put it in there. But there's two main theories, the textualist and the liberal activist perspective. So on the one hand, then, we have textualism, advocated most famously by Justice Antonin Scalia. He's pictured here. Very, very conservative Supreme Court justice. And as you'll see in your supplementary readings for this week, when we meet again on Thursday, we'll be having a little bit more discussion on these two different traditions, people like Scalia and Breyer and their positions on the Supreme Court interpretation of the Constitution in this regards. But Scalia's position is one of a very strict standard for constitutional interpretation. And his point is that the court should interpret the Constitution's writings faithfully, basing its decisions on the words of the actual document, but also its understanding of what the framers meant, right? So looking at the debates, the published debates between the framers about the various clauses of the Constitution as they were put together. So it's a very literalist interpretation. They're going back, they're trying to understand what the framers originally meant and what the words actually mean. And the idea is that the Constitution is the Constitution is the Constitution. The interpretation should never change. The Constitution has the same truth in it back then as it does now. And you might say, well, that shouldn't surprise you. But actually, there's a large number of people that object to that perspective on the Constitution, because they say that instead of the Constitution being an absolute document, what it is a helpful guide. The framers could not possibly have envisioned the kinds of social problems and complexities that we have lived with today, right? The entire era of industrialization has come and gone. Now we're living in a very high-tech world, high-tech industries, a much larger country, a much more diverse population. How could the framers have put down truths that had no flexibility in them, right? Well, unless it's almost as if, if you look at Jefferson, he thought the Constitution should be rewritten every 7 years. he's a minority view on this, but it just shows you that even then, some people suspected that there needed to be some organic stretchiness, if you will, in the Constitution. So that's the basis of the other interpretation then. And the gentleman in the bottom photograph here is Justice Breyer, who argues that justices should be guided by a commitment to the democratic ideal of a self-governing people, which means that a self-governing people, that's i.e. us, right, the democratic citizens, we can look to the Constitution not so much as an actual document that we have to interpret strictly, but as a mirror reflecting something of ourselves back at us, that we check in with the Constitution to see how we're doing. It's a set of ideals and principles that we interpret as we are today. Okay? Obviously, you can see the implications of this when it comes to something like racism, or slavery, or equal opportunities of African Americans, for example. Right? When you put it in those terms, it makes absolute sense what the stakes are. Right? The people who framed the Constitution believed in slavery. Okay? And the Constitution doesn't really give any opt-outs for that. Right? But in the last decades, the Supreme Court did decide that the values of the Constitution, as interpreted today, were a little bit different to the values of the Constitution as they were interpreted back then, right? We'll go into more detail on that next week, but it just shows you how important this question of interpretation actually is. So this is the position known as liberal activism. Now I can tell you, even further on the left, if you will, right? There's a perspective that says, hang on a minute, you liberals who believe in this activist principle, right? How many times have you actually won battles this way, right? How many times have you actually had victories for your political cause this way? And the answer would be very rarely, right? There's a handful of really important cases that seem to carry a certain progressive, popular democratic momentum, but throughout its history, 90% of the rest of the time, the Supreme Court has argued in favor of increasing federal power, taking power away from the people. It's argued extremely problematic perspectives on race, and it's largely taken power away from Congress to adjudicate over financial and economic matters, protecting the interests of those who have money and power to speak loudly about their views while everyone else doesn't have that power. So in terms then of race, of commerce, and the general increasing of power of federal government goes the progressive skeptical position. Those liberal moments of interpretation have been hiccups in a broader history of fairly strict interpretivism. So I said we'd take a break in a moment, or about halfway. I'll do that after this slide, okay? Just for 5 minutes or so. So just a little bit, the next 2 or 3 slides we have the Supreme Court, a history of the Supreme Court. And the first Chief Justice of the Supreme Court, as we've mentioned already, was John Marshall. And the important case that we need to know about there is the one of judicial review. The Marbury case, made the Supreme Court an equal body to the other branches, and it could review or interpret the laws of those other branches, effectively being able, therefore, to say what those other branches actually meant when they expressed their view, and perhaps even therein effectively vetoing the express wishes of those other branches, which is, as you can imagine, a huge power. The other cases that are listed here are also very important in terms of giving the court a federal power over the states. And if we think about the McCullough case, which you may have heard about before, it's another very powerful case which gives, in the early history of the Marshall Supreme Court, that gives federal government power to act in the affairs of the states. And the basis of this is the Constitution's so-called Commerce Clause. Anything that involves what the Supreme Court has interpreted to be intra-state commerce, right? That's commerce going from one state to another, right? Anything that affects that, the Supreme Court says federal government has the ability to claim jurisdiction. So think about that for a second in a broadest possible interpretation. That means that a hotel, for example, in the Deep South in the 1950s that says no blacks allowed, right? That could actually be, because it has a commercial stake, and it could, in principle and in theory, be accepting guests from out of state. It's a hotel, after all, jurisdiction, right? So it's depending on how you interpret the Commerce Clause of the Constitution, you could get a lot of federal power out of that. And that's what John Marshall's doing here. He's combing through the Constitution to get his teeth into any aspect at all that could be arguably giving the federal court power at the local level, at the state level. Okay? That just to give you a sense then of the gravity of those early cases. We'll talk about Gibbons versus Ogden another day for the sake of time. But McCullough versus Maryland, very important case in that regards. And it just shows you the power of the Supreme Court. And that it wasn't clear that the Supreme Court would have that power. At the beginning, it had to be argued, right? The people had to be persuaded that this was so, right? They were just interpretations of the Constitution until they were, as they say, real. When the Anti-Federalists got into power then under Jefferson, and then later with Andrew Jackson, they hoped to reverse some of these interpretations. But of course, the cat was out of the bag, right? There's only so much that they could do, right? The Supreme Court had already got standing. Just because there's an anti-federalist president doesn't mean the Supreme Court's not federalist. Even if it has anti-federalist judges, those decisions, because of stare decisis, are not easily reversed. So the laws of the land had been decided. Stare decisis, as we talked about at the start of the lecture, means that turning around interpretation of Supreme Court decisions is like turning around an oil tanker. It takes a long time. You have to decide, like, you want to take the right-hand turn, you've got to decide like 2 hours ago and get that rudder going, because there's just so much momentum in the bulk of the ship carrying it forward. And it kind of has to go, scoot off this way and then off, right? So it's not hard to turn, it's not easy to turn these things around. Forgive my clumsy metaphor. Jackson appointed Taney as Supreme Court Justice. And interestingly, one of the things we need to know about that is that one of the issues that was driving the tendency towards federalism was slavery, right? Because, of course, at the local level, there were states that liked having slavery and needed it for their economies, right? So one of the decisions that Taney decides over is Dred Scott, which is considered to this day to be a black stain on the history of the Supreme Court. Right? Dred Scott, interestingly enough, himself, do you know the story of Dred Scott, right? He was a slave that was taken from one state to another, And the state that he'd been taken to was a state where there was no slavery. He was taken to Illinois, basically, I think. Right? And in a bit of a miscalculation, Taney thought that the court could do something as big and as bold as decide the issue of slavery in this case, right? Because having been taken to another state, Dred Scott says, well, there's no such thing as slavery in this state, I'm free, okay? So black people in this state are free, right? So therefore I am free. And Taney says, not so fast. You were born as a slave, and so therefore technically it's impossible for anybody to leave the status of being a slave except by the express wish of their master to release them. And so you, but you cannot politically claim, there's no political basis for your claim to be a non-slave anymore. You cannot introduce a slave as a member of the political community is effectively what he said. That's actually what he said, right? The political community is this, slaves are that. You have no standing as a citizen, in other words. So Taney thought that that would sort of solve the whole problem of the slavery issue. And his solution, of course, clearly had a ring of protecting, even though it was in some ways, nominally it was a popular democratic decision. In fact, it seemed to appeal to values that were relevant to the South and Southern economic priorities. Okay, so we're going to talk now about some of the more contemporary history. So, just about some of the more contemporary history to bring it up to date then, we just, we'll have not too much time left, 15 minutes or so, 20 minutes. One of the important things that we need to understand, of course, is that what John Marshall had been trying to do in the Supreme Court, of course, was one thing. The actual settlement of many of these questions was not really resolved until the outcome of the Civil War, and you can imagine why, okay? So I suppose, sadly, it took a determination on the battlefield to figure out whether the Supreme Court was going to continue to have federal standing. Since then, the supremacy of the federal government over the states has not really been challenged, not very much anyway, and historically speaking, it's largely gone federal government's way. After the Civil War, the Supreme Court became preoccupied with Marshall's other major concern, not so much federalism and this question of federalism, but now it became about this question of economic rights and property rights. And so after the Civil War, the Supreme Court's activity largely focuses around less urgently political matters, okay? So the Supreme Court became a staunch defender then, after the Civil War, of property rights and laissez-faire economics, as it's sometimes called. If you don't know what laissez-faire economics is, it's largely thought of as free market economics, okay? Whereas the popular Democrats at the time and through those times would have been trying to, say, mitigate some of the worst or control some of the worst violations of the large industries of, say, workers' rights, workers' health and safety. The court was generally striking those down. One key example, and I should have put it on the screen, but it's not up there right now, is the United States versus E.C. Knight Company of 1895. That's the United States government versus E.C. Knight, as in Knight in Shining Armor Company of 1895, which was a sugar monopoly, right? That's to say that most of the sugar in the United States, the price of it was being controlled by this company. The American Sugar Refining Company, as it was known. And the court ruled in that instance that actually, and here's an odd one, right? Manufacturing was not covered under the Commerce Clause. We've discussed the Commerce Clause earlier on as having potentially very broad interpretation, right? That a motel, for example, because of its status in interstate commerce, could be interpreted as part of the federal government's jurisdiction. Here in 1895, in this E.C. Knight Company case, the court is ruling that manufacturing is not under federal jurisdiction. And so in other words, the federal court was not going to have a trust-busting power. When I say trust-busting, what I want you to understand me as saying is that anywhere you see a monopoly emerging, right, where there's only one person that's supplying that good or service to a market, and that person can therefore set whatever price they want, i.e. sugar, because everyone loves sugar, and they'll buy it at a high price, they'll buy it at a low price, but they're going to get their sugar, right? Isn't that a Simpsons joke?
Probably.
I think Homer has a I love America. First you get the sugar, then you get the money, whatever. So the prosecution had been trying to enforce what's called antitrust legislation. And antitrust legislation is a strange term, right? Because you'd think it means fighting against trust. Who wants to fight against trust? Trust is a good thing. But as it pertains to economics, trust is when someone's acting in a monopoly fashion. Say you have 2 or 3 guys, they're the major suppliers of a good, and they are acting in cahoots to set the price and force the price on the people, as opposed to letting the market's supposed to allow the lowest price to emerge because of competition. So antitrust is intended to restore competition, is the point, and get those sugar prices going according to the logic of the market again, where the person that wants to compete the most is going to set the lowest price. So it suggests that the Supreme Court was being very picky at that time about how it was interpreting the Commerce Clause. It was having its cake and eating it too. It was saying, yeah, we're federal government, we have this power over pretty much everything via this Commerce Clause, but not manufacturing, darlings, because that's where our buddies are. And we kind of like those sugar industry guys, and they give us, they give our friends a lot of money, and they give our political party a lot of support, right? So it kind of looked like a bit of corruption there on the Supreme Court side of things, right? After World War I, this laissez-faire kind of attitude, this pro-market financial elites attitude, hardened a little bit. And it was, in fact, this majority of the Supreme Court that fought probably some of the hardest battles in Supreme Court history when Roosevelt came to power. And as you know, Roosevelt was in power during what we know as the Great Depression. And as president, he believed that part of the problem was that there was too much money being sat on by the wealthy elites of the country. It wasn't so much that the country was poor. There was a Great Depression on, but it was hugely wealthy in some ways. If you look at the average wealth of the country during the Great Depression, it was enormous. But those rich people were not investing their money. Side note, eerie parallels with today, okay? Where we actually have companies like Apple sitting on $700 billion worth of cash reserves and not investing it in anything productive, right? When there's people unemployed, that suggests that maybe the system is not working as optimally as it might. But what the New Deal was about a set of principled policy decisions that were intended to get the money moving from the top to the bottom, not by cheating or stealing or taxing or whatever have you, maybe a little bit of that, but specifically to get government investment in the bottom of the economy so that government would be employing people, for want of a better word. It would be an actor in the economy of last resort, to use the technical economic lingo. And in making this move, Supreme Court, the New Deal, Roosevelt, was trying to get people working again. And the theory being that if you could get people working again, if you could get them going out to the stores then again, because they would have money in their pockets to spend in the stores, you'd be increasing what they call demand, right? And where demand increases, that's where your wealthy tycoons and all the rest are going to see an investment opportunity, because they're going to say, haha, people are buying more fruits and vegetables, clearly it's a good time to invest in fruits and vegetables. Or they're buying more hammers and nails, clearly a good time to get those factories fired up again. And so government, therefore, has, by acting temporarily in the economy as an employer, has restored a sense of prosperity and dynamic in the minds of private entrepreneurs as well. They see people consuming, they reopen the factories, and they get people back to work. Once the people are back to work, you can see a virtuous circle starts to emerge out of that. People are working in the factories, they've got cash in their pockets, they're going to the stores as well to buy even more fruits and vegetables, hammers and nails. And that virtuous cycle recovers you from the Great Depression whenever you have unemployment. So that was Roosevelt's proposition, okay? But in order to be able to do it, I'm summarizing terribly, terribly huge amount of history into like 10 sentences there. But Roosevelt was up against it with the Supreme Court, because as we've already established, the Supreme Court was very laissez-faire. It was pro the status quo. And they were going to be challenging a lot of things that Roosevelt was coming up with, policies that Roosevelt was coming up with to overcome some of these problems. Early in 1937, Roosevelt unveiled his strategy to try to overcome this problem. He claimed, somewhat deceptively it must be argued, nobody said any president was a perfect angel, that he was acting only to enhance what he called the efficiency of a court that was dominated by increasingly elderly judges, right? And he's like, these people are too old, look, they need help, basically, right? And they were getting on in years. But that's the thing about lifetime appointments, right? If you have the ideological person that on there that you like, why, you know, it's lifetime appointment, they won't go until they croak, right? I mean, or until they voluntarily step down. That's the system. So Roosevelt's like, these poor people, they need help, okay? And so he decides to put some young blood, and he basically calls their bluff. He proposes that the president be given the authority to add an additional justice every time a sitting justice over the age of 70 refuses to retire. Now, I don't know if that's still part of American law. I've always wondered that. But once you hit 70, if you haven't retired by then, the president can appoint another person. I'll have to check out and see if that's still the case. Because why? It's not anti-constitutional, because the Supreme Court isn't really specified in the Constitution. There's no size of the Supreme Court specified in the Constitution. So this was a political fiasco, right? Because it just does not go down well that the president would be seen to be interfering in this independent, autonomous political branch. But actually he won the battle, and after that the court moved away from its economic sort of protection of elite interests a little bit. So we just have a few minutes left here now, and I'm obviously not going to have time to show my little video clip that I wanted to show for you today, but I will post that for you on Blackboard, and maybe you'll have a chance to watch it in the coming day or two before we meet again. Or we can just watch it why don't we do that? We'll watch it when we meet here in class the next day. So Supreme Court, just in history, just to finish this up then. For several decades after the Roosevelt Revolution, the court's role largely centered on civil liberties and civil rights, and that's going to be our major focus in the next week or two, civil liberties and civil rights, okay? So we'll go into much more detail about some of these decisions then, but this is just a very brief summary. The Warren Court of 1953 to 1969 was generally seen, and is seen today, as a fairly strong individual liberties and rights of racial minorities centered court. In fact, many people say it's the most popular democratic court the country has ever had in its history. And many of the decisions that it ruled upon are still referred to today. Then came President Nixon, who appointed Warren Burger as a replacement for Earl Warren. Earl Warren's here in the photo. Yet the Burger Court, oddly, although Nixon had appointed a conservative, Burger in office as a Supreme Court justice seemed to change his clothing a little bit, right? He became more moderate. I won't say he became a popular Democrat, but he definitely was not the sort of conservative hatchet man that Nixon, I think, had been hoping he would be. And that can happen, right? When you put someone in a lifetime position and all they care about is the law, you know, they're passionate about it's their hobby, it's their life, it's their love. You know, who's to say that the things that they said when they were greasing for the position are going to be the things they end up having when they're no longer needing to be worried? I mean, in a sense, proving the value of what the founders had hoped, that, you know, these people with their lifelong appointments would be moderates. The Rehnquist Court then, a conservative jurisprudence largely shaped by the appointments of Reagan and Bush elder. And then when Rehnquist died, George W. Replaced him with John Roberts, and then shortly afterwards we had Samuel Alito also take over. So it was two more conservatives on the Supreme Court at that time. Now we have Obama, and we know that he's put in Sonia Sotomayor, and I think we're probably good for shifting around. No one's sort of immediately in the verge of retiring anytime soon now, but again, it just shows you that this dynamic, this sort of momentum in the Supreme Court continues to this day. I had a bit more to discuss with you today, but we can maybe cover it another time. A lot of it bleeds over anyway into civil rights, civil liberties issues, so we'll definitely have time in the coming week or two to recover that ground. As I said, I will post a little clip for you about Citizens United, because it's such an important Supreme Court case that tells you very much about the nature of the court today, returning to that theme of whether, having gone through the Roosevelt years, we're now seeing the Supreme Court returning to a sort of an economic attitude towards its own power. So that's it, guys. I'll see you on Thursday. This was good, right?
Good.
This was good. Okay, I enjoyed it. I thought it worked well. Thank you.